This fireside video is entitled Protecting the Home from Medical Creditors. Hello, I'm Vance Parker, a North Carolina elder law and estate planning attorney with Vance Parker Law. As people age, one of the biggest problems families have to deal with are extremely high unreimbursed medical costs. This video talks about the financial burden unreimbursed medical costs can place on a family following a loved one's death, and shares some good news about preventative legal techniques we can use to save a senior's home, family farm, and other real property from estate medical creditors. After someone dies, he or she leaves behind an estate, which is then settled at the county courthouse in a process called probate. In North Carolina, the probate process requires all estate debts and creditors to be paid before any of the heirs or loved ones are paid. At the end of their lives, many people run up very high unreimbursed medical or hospital bills. Unfortunately, even after death, any unpaid bills must be paid in probate before the decedent's loved ones inherit. These unpaid bills, which are often large medical bills, can create decimating family financial problems. Using Medicaid creates an even greater risk to an estate. Because a nursing home stay may cost $7,000 per month or more and is unaffordable to many families, 63% of Americans must use the Medicaid program to pay for nursing home or other long-term care expenses. Medicaid is a poverty program, however, not an insurance program like Medicare. Thus, Medicaid will ask for every dollar it spent on the Medicaid recipient during his or her life to be paid back by the recipient's estate after the recipient dies. Medicaid runs a professional, highly reliable Medicaid Estate Recovery Office in Raleigh, whose only job is to get Medicaid bills paid back to them from Medicaid recipients during the probate process. After death, it is not uncommon for a person's estate to receive a $50,000 or even $250,000 bill from the Raleigh Medicaid Estate Recovery Office, in addition to a $100,000 hospital bill, a $20,000 bill from a rehab facility, and a $10,000 physician's bill, with all of these bills needing to be paid back before any of the decedent's loved ones inherit. So how does a deceased person's estate pay off all of these health care bills? Unfortunately, during probate, any assets left in the estate must be used to pay the remaining medical and other bills. A person's home, their farm, or any other real property they own are frequently the most valuable assets remaining in their estate following their death. So, if the medical bills are too high, the decedent's home or family farm, or even real property, may need to be sold in probate to pay the estate medical bills. This can prevent the decedent's heirs, loved ones, and family, who may greatly need the property, from receiving it. Now, how can the home and other real property be protected in advance from medical creditors? As part of a real property creditor protection legal planning process, a North Carolina elder law attorney can use some specialized legal techniques to protect real property from later estate creditors. Here are a couple of tools that an elder lawyer can use. 1. Joint with right of survivorship ownership. If the home, farm, or other real property is owned by the client without a mortgage, the real property ownership can be restructured to make it like a joint bank account which has survivorship rights. After real property has been changed to joint with right of survivorship ownership, it will pass immediately and directly at death to heirs, totally bypassing the probate process. Current North Carolina law indicates that such transfer is likely free of creditors, and Medicaid estate recovery does not go after real property transferred in this manner. In addition, under current Medicaid property ownership definitions, an elder law attorney can convert real property formerly counted as a Medicaid asset to make it exempt and no longer counted as a Medicaid asset. Real property transferred using the joint with rider survivorship technique is not subject to the 5-year look-back requirement, so we may set up a joint with rider survivorship transfer at any time before qualifying for Medicaid. 2. A life estate deed. A life estate deed may be created where the client deeds away the remainder interest in his real property to his children or other heirs, while retaining a legally enforceable life estate interest in the property. This technique may protect against all future creditors, including estate medical creditors. But, unlike the joint with rider survivorship technique, a life estate deed must be set up more than 5 years in advance of needing Medicaid, because Medicaid treats a life estate deed like a gift subject to its 5-year look-back requirements. Thank you for watching.